disclose information to my boss or my business partners or my spouse. First, we need to make sure that your lawyer is truly your lawyer and your lawyer alone. As a rule, lawyers are bound by extremely strict confidentiality obligations and a duty of loyalty to their clients, which would prohibit disclosure of anything you say on the phone or in person, or write in an email or text to any third party. But I want you to take a look at the engagement letter you signed and confirm that the client is you and you alone. So for company representation, let's say that you are the CFO of a closely held LLC. The owners have engaged a law firm to represent the company, and they direct you to speak with the attorneys regularly on the company's behalf. The lawyer should make it clear to you up front that they are representing the company and not you in your individual capacity. Between the terms of the engagement letter and applicable ethical rules, this can get extremely complex. But in general, you should expect that the lawyer's duty is to the company itself, and potentially also to its owners, and not to you personally. If your interests are in conflict with those of the company, you're going to want to retain your own counsel. And you shouldn't treat the company lawyers as your own personal attorneys, even if you develop an affable working relationship with them over time. Their duty is to the client, that is the company, and not to you personally. Business partners. Similarly, if you engage an attorney for your company with your business partners, the engagement letter will probably state something to the effect that the lawyer is representing the company itself and not any particular individual's interests therein. Or, if it is a joint representation of all business partners, the engagement letter might state that there is no duty of confidentiality as between the engaged parties. This means that the lawyer may have an obligation to include all business partners on any phone calls or to CC everyone to any email, and you might not have the privacy that you expect or desire as you would if you were the sole client. Finally, spouses. If a lawyer is jointly representing you and your spouse, it is very similar to the business partner scenario that we just discussed. Generally, marriage is going to be a special relationship of trust, and your business interests are going to be aligned. But if you are, for example, contemplating restructuring your company to facilitate a division of assets in the event of an imminent divorce, you really do need to get your own independent counsel, even if you and your spouse have shared the same trusted corporate attorney for years. Now, there's also a separate set of exceptions for things like situations in which the client is going to cause imminent harm to self or others, or defensive malpractice claims, or reporting requirements, but we'll save those issues for another day. Business owners. Were any of the potential confidentiality exceptions that I discussed surprising to you? If so, well, first discuss with your own independent counsel to make sure you're protected going forward. But then after that, I'd welcome your input in the comments.